My name is Chris Achatz, and I'm part of the privacy team here at KO. And Erin, why don't you introduce yourself?
Hi everyone, my name is Erin Locker. I am also part of the privacy team. I've been with KO since March of this year, and my practice focuses on privacy, security, data protection, kind of all things related to data. So looking forward to this presentation today.
Okay, thank you. And so that's kind of makes up rounds out our privacy team here at KO. If you've just joined, we just want to state that we will be answering questions at the end. Please ask them in the question answer feature. We've disabled the chat and the raise hand feature, but we'll be looking for questions at the end. So ask those in the question answer feature. So today we'll be discussing the recently passed CPRA. I should start off by saying the CPRA is highly technical, and I feel like every time I start talking about the CPRA, I almost have to apologize just because it's so technical and so detailed. In that there's a lot of substance to cover here. It does assume that you understand that the modifications of CCPA and that you are aware of kind of the basics of the CCPA. We won't be diving deep into the CCPA for this presentation, but what we will be doing is we will be trying to cover some of the background of the CCPA and how it's modified by the CPRA in each of the topics that we'll cover. So first, we're going to start off with discussing, what just happened with the CPRA, and then kind of the list of the top 10 changes that we think that could affect your business. And then we'll talk about what are the next steps and hopefully save time for questions. And again, ask those questions. If you just joined, ask those questions in the question and answer feature here. So I'll pass it to Erin.
So the California Privacy Rights Act of 2020 was actually a ballot proposition in California, Prop 24. So in the election, which I guess feels like yesterday, the Prop 24 passed on November 4th. The effect of Prop 24 is to update and amend the CCPA, which was the privacy law that went into effect on January 1st of this year. So at this point, we haven't even had the CCPA for 11 months. And here we have the CPRA, which will entirely amend and update most provisions of the CCPA. So the group that actually proposed Prop 24 was the original group that promoted a ballot initiative in 2018 and essentially forced the hand of the California legislature to go ahead and pass the CCPA within about a week. They had garnered enough signatures to get it on the ballot. And then now that the CCPA has been in effect, the same group promoted the CPRA, or Prop 24. So this is really all coming from kind of the same group of consumer privacy advocates in California. The stated purpose of the law is to further protect consumers' rights in California, including the constitutional right of privacy under their constitution. This is not something that every state has, we should mention. So one reason we hear about California law in the privacy and security space is they both pass a lot of the leading laws in the country, but also they have a recognized right to privacy under their constitution. One good thing about the CPRA is that it won't be effective until January 1st, 2023, which gives us all about 2 years to prepare. There's also a delayed enforcement date of July 1st, 2023. And in that time, there will be a number of regulations issued by the enforcement body, and I'm sure lots of developments in the industry will happen around how to comply with the CPRA. So just a couple facts from the election. It really, initially, the polling was showing that the CPRA would pass by a significant margin. In reality, it actually currently only passed by a margin of 56% yes to 44% no. There were a lot of kind of opponents who came on to the law at kind of the last minute. A lot of consumer rights organizations actually opposed the CPRA, saying that it did not go far enough to protect consumer privacy. But overall, I think one of the most significant impacts of the CPRA being passed as a ballot initiative is that there's only going to be very limited amendments to this in the actual legislature. So according to CPRA, California's legislature can only amend if The amendment passes by a simple majority, and the amendments are intended to enhance privacy and benefit consumers. So a lot of commentators think that to the extent the legislature actually tries to amend the CPRA, it will be challenged by consumer advocacy groups on the back end.
Okay, thank you, Erin. And so we're going to kind of walk through these top 10 changes that you're going to see with the CPRA. Here are the top 10 we're going to be walking through. We're going to talk about the new enforcement agency that's created by the CPRA called the CPPA. Sorry, we're dealing with like alphabet soup at this point with all these acronyms. We're going to talk about the new scope of covered entities, additional rights that are created, sensitive personal information, the private right of action, how that was modified, changes with regard to your privacy policy requirements and your contract requirements, and then heightened penalties for children's information, and then kind of exceptions that were created or extended under the CPRA. So first, let's talk about this new enforcement agency. So the California Privacy Protection Agency will be, when created, the first regulatory agency in the U.S. that is exclusively dedicated to privacy. So as Erin was discussing, most of the substance of the CPRA is operative or goes into effect on January 1st, 2023, but the CPPA is created and funded 5 days after the ballot is certified. And so we're thinking really like you're thinking, I think it has to be certified by December 11th at the latest. So December 16th, the CPPA will be funded, and then it will be governed by a 5-member board. That will be created about 2 months afterwards. And then also they will appoint a chief privacy auditor. What you'll see with the CPRA is that assessments and audits plays very prominently over and above the requirements of the CCPA. Most of the details there with regard to assessments, audits will be passed in the CPRA regulations. And we'll talk a little bit more about that, but just note that audits and assessments plays prominently and that this chief privacy auditor will be appointed. The primary purpose of the CPPA is to administer, implement, and enforce the CPRA. It has regulatory power, and it can issue administrative fines. As part of that, it has investigative, subpoena, and audit power. Again, note the audit power and note the chief privacy auditor that will be created. The CPPA will take rulemaking authority from the California Attorney General, meaning that we will get another set of regulations. I think everyone here is very familiar with kind of the detailed and many the prolonged process to get to regulations. I think we're still getting sometimes modifications to those CCPA regulations. And so it's an arduous process for sure. If you're interested in the regulations, we do have a recording that we can send you on that where we've discussed those. We won't be discussing the regulations as much today, but know that there will be additional regulations under the CPRA. The enforcement for the CPPA begins, as Erin stated, on July 1st, 2023. There is a 30-day, I'm going to call it a air quote cure period here, but basically how it would work is the CPPA would provide written notice of a hearing, for where they would determine if there was probable cause that the CPRA has been violated, and if within that 30 days before the hearing, the company can cease and desist the violation, or if they go to the hearing and the CPPA determines that there's probable cause, then they can issue administrative fines. What I've noted here in red is the changes with regard to the CPRA. And so what's in black here was what was already under the CCPA and what is currently in effect. And we're going to get into kind of the extension on the private right of action. Erin's going to talk about that, and Erin will talk about the violations involving minors and the additional fines that are under the CPRA. I'm going to focus on this last bullet. The CPPA can issue administrative fines after this 30-day period, and the penalties are they're $2,500 per violation or $7,500 per intentional violation or violations involving a minor.
So one big change with the CPRA is kind of a difference in the definitions of the entities that are covered by the law. So currently under the CCPA, the law defines 3 types of companies or organizations that must comply. There's covered businesses, service providers, and third parties. The CPRA it still includes those 3 basic entities. They do kind of update the definition of each of it, and the CPRA also includes a new category of organizations called contractors. So under the first big change is the change to the types of businesses that are covered by the CPRA. Those of you who are familiar with the CCPA will remember that there's essentially any for-profit entity that does business in California, collects Californians' personal information, determines the purposes and means of the processing of that personal information, which in other words means they are, the data controller as we think about it under European data protection law. And then in addition, the business has to meet 3 thresholds. So there's still 3 key thresholds to look at when determining applicability, but they're a bit different than what's under the current CCPA. The first, so businesses that had annual gross revenues of $25 million or more in a year are still subject to the CPRA, but the CPRA clarifies that that calculation starts on January 1st. So I know some businesses have had to figure out, what if we hit $25 million in revenue, this coming year? Should we consider ourselves subject to the CCPA? So the CPRA will clarify that it's only as of January 1st of the calendar year. If you had 25 million in gross revenue in the previous year, you will be, you'll meet the threshold to qualify as a business under this definition. The second threshold under the current law require businesses that process information of 50,000 or more consumers' devices or households to be subject to the CCPA. The CPRA actually increases this number. So now businesses that buy, sell, or share the personal information of 100,000 or more consumers or households will be subject to CPRA. So that's 50,000 additional consumers, and the CPRA also removes the definition of devices from this threshold category, which I think sometimes when businesses have been looking at the amount of California data they're processing, one thing that comes up a lot is, what if a consumer is using a mobile device, a desktop, an iPad, and all of these devices, do all these devices count as, one single consumer? And the CPRA clears that up and basically says, no, it's not based on the number of devices, but the number of actual consumers or households. And then finally, the last threshold is businesses that derive 50% or more of their annual revenue from selling or sharing a consumer's PI. And we'll get more into this definition of sharing. It's not just any type of sharing of personal information. It's related to cross-contextual advertising purposes. So we'll go into that in more detail later. So there's a couple other different businesses. The second type beyond the threshold requirements is an entity that controls or is controlled by a business that meets the thresholds I just discussed under number 1, has common branding with that business, and that business has to be sharing personal information with the entity. This is really similar to the current definition of business under the CCPA, but it clarifies that a related company will only be caught up in the CPRA if they're receiving personal information from an affiliate or a subsidiary that's otherwise covered by the CCPA or CPRA. The third category is actually new. It includes a joint venture or partnership composed of businesses in which each business has at least a 40% interest. This is not a category under the previous law. And then finally, the CPRA adds a fourth category, which is any other person who certifies to the regulatory or the enforcement agency that they are in compliance with the CPRA. So finally, service provider and third party were already concepts under the original CCPA. The definition to service provider, the only slight difference is that the CPRA clarifies that it's a person that processes personal information on behalf of a business for a business purpose. which won't really change the concept, I think, in a lot of cases. The CPRA also adds the idea of a contractor, which is a person who receives personal information from a business for a business purpose. So not necessarily an entity that's processing PI on someone's behalf. Maybe they're performing services directly for the business, like auditing or other purposes. But really, the addition of contractor was intended to include, all potential companies that might be receiving personal information. So that's going to affect the contractual restrictions that need to be in place, which Chris will get into a bit more. And then finally, the CPRA provides a few clarifications about what constitutes a third party. So essentially, a third party is anything that's not a service provider, a contractor, or the business that's directly collecting personal information from the consumer when the consumer is intentionally interacting with the business. So, this might be third parties that are collecting data through pixels and tags on a website where the consumer may not be directly or intentionally interacting with that entity to the extent it's not, the provider of that cookie or pixel is not otherwise a service provider contractor. So with that, I think that covers all of our categories. Chris will talk about, or actually, no, I'll keep going. I'll be covering some of the additional consumer rights under the CPRA. So under the current CCPA, we have a couple different rights. I've highlighted the 4 kind of key rights here. California consumers have a right to access information and specific pieces of their personal information. They can ask a company, a covered business, to delete their personal information. They can ask to opt out of the sale of their personal information, and they have a right to exercise all of these rights without discrimination in the form of a difference in price or service. Under the CPRA, first, there's been a couple changes to the existing rights of access and deletion. So currently, if you're subject to the CCPA, you are only required to provide access rights relating to personal information you've collected in the preceding year, the last 12 months. The CPRA actually expands this right and says, anyone who submits an access request and it's verified and you go through the identity verification process, you must respond with all personal information that you have on them from any time, unless it proves impossible or would involve a disproportionate effort. So in some cases, this may significantly expand the amount of data that covered businesses are required to provide in response to these requests. The right to deletion was also expanded. Previously, businesses were required to delete the personal information they maintain, as well as direct their service providers to delete that information. Under the CPRA, that direction must now also go to contractors and any third parties to whom the business has sold or shared such personal information. So one of the new rights provided for under the CPRA is the right to correct an individual's personal information. So this is really similar to under the GDPR. This is something that already exists. So for businesses that are already complying with the GDPR rights in Europe, this will be kind of a very similar effort on an organizational standpoint to correct any inaccurate or incorrect personal information. There's also a right to access and opt out of automated decision making in the CPRA. There's really, under the current ballot language, there's not much guidance on what this will look like, but the CPPA is expected to issue regulations that will govern these rights. So we'll get a lot more information about how this particular right will look in the future. The next right is the right to opt out of the sharing of PI. So something that, as many of you I'm sure are familiar with, the right of consumers to opt out of the sale of their personal information is something that currently exists under the CCPA. The concept of sale it generally means anytime you're sharing personal information with a third party for monetary or other valuable consideration. And since the CCPA became effective, there's been a lot of different kind of positions taken and arguments for whether, different types of sharing actually constitutes a sale, because the CCPA didn't provide much detail or guidance even on what is the meaning of valuable consideration. When you are sharing data with certain advertisers, is that, something that might be for valuable consideration if you're not receiving money in return? There's not a lot of clarity in the original statutory text, and the Attorney General never, the regulations never weighed in on whether, certain types of sharing, especially for advertising purposes, actually rose to the level of the sale. The CPRA solved that for us and now includes the right to opt out of the sharing of personal information, which is really be any communicating, making available, sharing, disclosing, disseminating of any consumer's personal information to a third party for cross-context behavioral advertising, whether or not for monetary or other valuable consideration. So this clarifies that, in fact, a lot of the sharing for advertising purposes will be covered under the CPRA, and there will be a new requirement to provide an opt-out link as well. And then finally, the last additional right is the right to limit use and disclosure of sensitive personal information. So this just applies to businesses that collect these categories of personal information, and the consumer has the right to limit to just what is necessary for the company to perform the services and other limited purposes prescribed by the CPRA and future regulations. And Chris will go a little bit more into what that new definition looks like and what this right may mean for businesses.
So yeah, I'm going to do that right now. So first, let's just talk about what is covered under this definition of sensitive personal information. So I've listed all the data elements here that are covered under the definition. There's about 20 of them. First, let's talk about where do these come from, and where is their crossover with other laws. So basically, what we see is it's basically like kind of an amalgamation of sensitive, and I'm kind of air quoting here, types under other laws. What you have, you're very likely aware, under the CCPA, there's no definition for sensitive information, but the CCPA regs make clear that the data elements that are listed under the California state data security law are presumptively sensitive. I've kind of done a cross-reference here on the first column that you see here. We also know is that the data elements that are listed in that California state data security law are the data elements that would be subject to that private right of action if there was a data breach that Erin will be talking about a little bit more in depth as we move through here. We also know that there are definitions of sensitive data under other laws. Primarily let's focus on the GDPR. There's a definition of sensitive personal data, and you can see here the cross-reference here that they are also included. There's, I think, one that was not included for political opinions, but otherwise they're all included. And so basically what we can say is that some, but not all, of the sensitive personal information data elements that are covered under the CPRA would trigger that private right of action that we know is present in the CPRA and are linked to the California state data security law. What we also know is that some, but not all, of these data elements would also trigger the opt-in consent requirements with regard to sensitive personal data under the GDPR. And two, as you see here, would trigger both, could potentially trigger both if both the CPRA and the GDPR were applicable. So really interesting definition here, broader definition, maybe a bit less with regard to requirements. And I'm going to talk about those right now. First requirement, and I'll talk about this a bit more when we talk about updating the privacy policy, but you have to list the categories of sensitive personal information. So let me pin that for a moment and I'll get back to that. But I think what is getting more attention is this second requirement, that and this is basically a new consumer right. Think about it as almost like a right of restriction under the GDPR. It is or maybe you can think of it as like an opt-out right. It is actually, when you read the requirements with regard to sensitive personal information, they are all lumped in with the opt-out right for sale and sharing that Erin's talking about. So they're basically lumped right together. So you can think of it as an opt-out right. Now here, importantly, the right is applicable not to selling and sharing, it is applicable to use and disclosure of sensitive personal information for purposes that are beyond those necessary to perform the services and provide goods reasonably expected. So the consumer has this limited right to restrict uses that are outside those purposes. There's also some exceptions to the right, such as ensuring security, integrity, short-term transient use. There could be some kind of non-cross-contextual behavioral advertising, some limited non-contextualized advertising that maybe fit in under that. Performing services on behalf of the business and maintaining the quality and safety of the service or device. And there should be also the CPRA flags for the CPRA regulations to come up with additional exceptions. So what does this mean? That the right to basically opt out or provide this, the link to the not using or disclosing sensitive personal information is not an absolute right. There are exceptions to that right. But to the extent the business is using or disclosing sensitive personal information for a purpose other than as authorized by the consumer or one of those stated exceptions, that's when the requirement for this new hyperlink triggers. And there's three options for implementing that hyperlink. One is you can have a separate hyperlink and the text is provided at limit the use of my sensitive personal information, and it can go right next to the hyperlink for do not sell and now share my personal information. It can be combined into one hyperlink. The text for that hyperlink is not provided by the CPRA, so we can get creative, I guess, until the regulations come out. Or you can respond, the business can respond to an opt-out preference signal that accomplishes 1 and 2 here. Again, we don't have guidance on that preference signal or how it would operate or the scope of that because it has been slotted to basically determined for the during the CPR regulations, that rulemaking process.
The next big change under the CPRA is an expanded private right of action for certain types of data breaches. As you may remember, under the CCPA, currently the only recognized private right of action is when a company experiences a data breach involving specific elements defined under California's data breach law. So things like a first and last name with a social security number, a driver's license number, some of the typical categories of PII that we consider to be sensitive that we would usually expect to see kind of a data breach notification about. And a lot of these categories are the same across all 50 states. Under the CPRA, the private right of action is also expanded to data breaches involving usernames or email addresses in combination with a password or security question, an answer that would permit access to an online account. So really, this could significantly impact the scope of the private right of action. There's a lot of data breaches, especially recently. I'll get into some specific numbers that involve incidents where usernames and passwords are stolen. We see that in the news. It feels like almost every day these days. So under California's law, businesses will both be required to disclose data breaches involving usernames and passwords to consumers and the Attorney General if 500 or more individuals are impacted. And then with the CPRA in effect, it will also bring in a new risk of liability because consumers will have the right to file a direct suit for those types of breaches. And the existing statutory damages under the CCPA will still apply. It can be up to $750 per consumer per incident. So there's no actual harm requirement for consumers to file this type of lawsuit, but the CPRA does give businesses the opportunity to cure. Interestingly, some of the text of the CPRA actually limits the right to cure for data breaches. It says, basically, if you implement and maintain reasonable security procedures and practices following a breach, that does not constitute a cure for the existing breach itself. So there's already been a lot of questions about how businesses will be able to cure breaches. You can't go out and take back data that was stolen, or you can't, reverse the harm of identity theft if it occurs. So bringing in, credential theft breaches where usernames and passwords have been out on the internet, there's some new questions to think about. In some cases, typically a business, if this happens, will reset passwords, alert the users that this has happened, maybe increase protections around the account, but it still raises the question we see a lot, consumers will use passwords for many, many different accounts. So it does raise the question, what is sufficient for a cure here? If you just change the passwords of your own users after a credential breach, is that enough? Or are these even things that can be curable if consumers are using the same username and password combination across the internet? I think overall the impact could be significant. Last year, the theft or use of stolen credentials was involved in 37% of data breaches. This is very, very common. There's a website that tracks a lot of stolen credentials called haveibeenpwned.com, and I looked at the total number of credentials stolen reported on their site yesterday, which was over 572 million. So this is not, these types of incidents are very, very frequent, and not even something necessarily that businesses have to disclose in all states. There's only a handful of states that include username and password as a trigger type of data that would require notification to individuals. So it's going to be really important kind of in the next 2 years to look at security around, those user tables and the databases containing credential information to help, manage some of the risk of liability around these types of incidents.
Okay, so I'm going to talk about the privacy policy requirements, the changes to those requirements, and then I'm also going to talk about contract requirements following this. So let's dive into how privacy policies will change. So first, let's focus on that sensitive personal information changes with regard to sensitive personal information. So I kind of indicated earlier and pinned that we will, now there's a requirement that for businesses that are collecting sensitive personal information. Remember also that the notice and disclosure requirements under the CCPA are only applicable to businesses, not to service providers or contractors now or third parties. It's applicable to businesses. So if the business collects sensitive personal information, one of those 20 plus data elements, they have to list the categories of sensitive personal information. That's a little bit interesting to link it to categories, because sensitive personal information is in of itself a category of personal information. I think what is being referred to there is that the actual data elements need to be disclosed under this requirement. So it'll be very interesting to see how that's implemented. Likely, if you've already updated your privacy policy for the CCPA, this is just an expansion of that. I see a lot of tables in privacy policies where all the categories are listed. You probably could see an expansion to that table. The purposes for which those categories of sensitive personal information are collected or used, this is actually probably not much of a lift here because you can link it to the full set of purposes, the use section of your privacy policy. It's not the purpose for each category. So it's at one time under the CCPA regs, there was a required linking for each category, all of the purposes for that particular category. We do not see that with regard to sensitive personal information, and that no longer exists with even regard to personal information. But this is the requirement here. List of the categories of sensitive personal information that are sold or shared about the consumer. And then also, again, if the business is using the information, the sensitive personal information for a purpose beyond one of those exceptions that we discussed earlier, this hyperlink to limit the use of my sensitive personal information, or those other options that we discussed earlier. There's new rights for consumers, and Erin already discussed this. There has to be a disclosure with regard to the consumer's rights to request correction of inaccurate personal information. We've been talking about this quite a bit. The updating all references to the opt-out of sale right to now the opt-out of selling or sharing right with regard to cross-context behavioral-based advertising. There's also, and this is a bit technical and an interesting one, but and I'm just going to jump right down to the end here for brevity, but there's an exception to the obligation to have 2 or more designated methods for submitting these requests, and that exception is for businesses that operate exclusively online or have a direct relationship with the consumer, that they can then only have an email address listed, not two methods for submitting requests. Now, you may remember in the CCPA regs, there was a limited exception, probably a smaller version of this, with only with regard to access requirements. There also was a requirement that if you need to provide an opt-out of sale link, that you then have the interactive web form. That seems to be in conflict with this broader exception under the CPRA. So that's kind of interesting. It's one to watch and could be very useful for any of our SaaS companies out there, but that's a useful one. There's also a new requirement with regard to retention, that the business has to list the length of time that the business intends to retain each category, so a category by category listing, or the criteria used to determine the retention period. That kind of criteria used to determine the retention period is what most controllers use with regard to the retention disclosure requirements under the GDPR. So it'll be interesting to see how that's used, but to the extent that, I think like technical compliance with regard to the CPRA here would require a listing of the length of time for each category for all personal information categories. So that could be an onerous requirement that could, necessitate a bit of data mapping. So one to certainly watch and see how businesses are implementing that requirement. Let's now switch to the contract requirements and how they've been updated. And I want to start here, and we're going to, I was actually thinking about maybe moving past this, but we're getting some questions with regard to these legal entities again. And I see that Tamara and Steve. So I'm gonna cover this again, what Erin covered. What we're used to under the CCPA is this kind of flow down obligations between businesses and service providers. And you see those generally memorialized in the contract, usually in the form of a data processing addendum. There's also this third party, I'm going to get to them, but this is what we're used to under the CCPA. Under the CPRA, you have this new concept of contractor. Let's handle that first. As Erin talked about, these are basically the same thing. And I've kind of put back up the definitions here, but a service provider is a person here as defined as a basically business entity under the CPRA. It's a defined term, but the person that processes personal information on behalf of the business and which receives personal information for a business purpose pursuant to a written contract. The contractor is the person to whom the business makes available that personal information for a business purpose pursuant to a written contract. Your brain may be hurting, or maybe that's even generous, maybe exploding at this point, because you can imagine putting these on a Venn diagram and you might think, well, if a downstream entity, if it receives personal information, it may also be that personal information was made available to them, and for entities that personal information was made available to, they might also be receiving the personal information. So, first, is there a difference here? I mean, if you were to do, and this is obviously what Erin and I do on our weekends for fun, if you were to run basically a control find for service provider and you were to map out all the obligations, you would find that every single obligation that applies to a service provider also applies to a contractor, and similarly, every obligation that applies to a contractor applies to a service provider. So, or both, vice versa. So just note that at this point, this is an interesting distinction that doesn't have much weight. Maybe in the regulations, we'll see something come out of this. But at this point, no, I think, Erin and I are trying to read the tea leaves, and we've talked about this. I think what was the drafters were trying to accomplish with these two definitions is that there were some maybe creative businesses out there that were trying to get around the service provider contractual obligations by defining a new class of entities as contractors and not service providers. And so I think they're really just trying to close that hole that may persist in some contracts. Now, as Erin talked about, if you're not the business that's interacting directly with the consumer, and you're not a service provider, and you're not a contractor, you're a third party. And so that kind of rounds out the entities that are under the CPRA. And to Tamara's question, yes, the definitions of these the definition of these entities track to the controller and processor definitions. A business, as Erin mentioned, is an entity that determines the purposes and means of the processing, directly cribbed from the GDPR, and the service provider contractor is this downstream entity that receives personal information and processes it on behalf of the business. So interestingly, there's kind of two buckets of new contract requirements. There's contract requirements that are applicable to the third-party service provider and contractor, and that's big because the third party, even though it existed under the CCPA, or even though it exists under the CCPA, it does not have any direct contractual obligations. And then there's another set of contract requirements that only applies, and new contract requirements that apply to just the service provider and the contractor. I'm going to cover first the broader set of contractor. And I think at this point, I'm going to start referring to them as the downstream partner, so you don't have to hear those names repeated in a list again and again. So these first set of contract requirements require that the business specifies the limited and specific purpose of the downstream use. It obligates the business partner to represent CPRA compliance. It grants, the contract will grant the business rights to take reasonable steps to ensure that this downstream partner is in compliance with those obligations. It requires the downstream partner to notify the business if it's not in compliance, and it grants the business the right to take reasonable and appropriate steps. This seems like a lot of new contract requirements. In implementation and just writing too many DPAs, I think this basically comes down to like a paragraph. You're probably looking at, a sentence with regard to the downstream partner representing CPRA compliance, an obligation for the downstream partner to notify, and then to the extent the business either self-assess the downstream partner or receive this notice, taking some type of having a reasonable remedy if there's unauthorized use. And that's most likely a termination, right, is what you see in DPAs. So you're probably thinking about a paragraph there adding here. But the big change there, and again, worth noting, again, is that these now apply to third parties and not just service provider / contractors. There's also another set of contract requirements that are required under the CPRA, and these requirements basically they're on top of the requirements with regard to limitations on use, retention, and disclosure and selling that are already part of the CCPA. And on top of that, they add requirements that essentially bring up the CPRA requirements up to kind of a GDPR DPA baseline. First, this downstream partner shall provide reasonable assistance to the business in responding to consumer rights requests. That's, I think, what if you're reviewing a lot of CCPA DPAs right now, you'll probably see that obligation. That's not actually contained in the current CCPA, but many CCPA's addendums take the liberty and add that in. The downstream partner shall implement technical and organizational, that's cribbed right from the GDPR, measures to assist the business in monitoring downstream partners' compliance with the CPRA and permitting the business to implement its own reasonable security measures. That's straight out of the GDPR. This downstream partner shall permit manual reviews and authorized scans. Again, I'm going to keep hitting this under the CPR. It's big. Audits and assessments are big. Audits and assessments, as you see here, at least once every 12 months. That would be analogous, but maybe stricter than what you see under the GDPR with regard to obligations for record keeping and audit, and then also the obligation to assist in DPIAs, which is an assessment. So again, bringing it up to the GDPR standard, maybe even a bit more strict there with regard to the obligation for at least once every 12 months. And then basically I'm going to call them sub-processor obligations, obligation that the downstream partner will notify the business if it engages a sub-processor. That's less strict than the GDPR obligation to get general or specific consent for this sub-processor. But there's a notification obligation, and that the downstream partner's sub-processor agreement, so it's agreement with the sub-processor, or maybe it's data processing addendum with the sub-processor, will contain those same requirements as its agreement or data processing addendum with the business. So this kind of flow down obligations all the way down to sub-processors. The CPRA does not go as far as to saying that this downstream entity must be fully liable for the sub-processor, but I imagine that's going to get written in. And basically then your delta between what is under a GDPR DPA and a CCPA DPA, the delta would now be there's no obligations with regard to international data transfer requirements, because we don't have international data transfer requirements in the US. And also the CPRA does not cover reasonable security of the downstream partner. However, that is required under California data security statute, and the CPRA does not cover assistance with breach notification. That also is required in a separate part of the California code under the data breach notification statute. So, you know, I think kind of the takeaway here is that there's an intention of the drafters of the CPRA to bring the CPRA DPAs up to the level of what you would think of as a GDPR DPA.
The next big change under the CPRA is heightened penalties for children's information. The statute actually triples the amount of violations or the amount of fines and penalties for violations involving children's information under the age of 16. So currently, all violations are $2,500, while intentional violations are $7,500. Now, children's violations will also be set at $7,500 in penalties and fines. This is something that the California AG's office has already signaled that they're focused on, you know, children's data as an enforcement priority, and this kind of, I think, drives the notion home that generally California in general, and also these regulatory bodies, are going to be very focused on how businesses are applying the CPRA to any, you know, users they have 15 and under. And in particular, they'll likely be looking at kind of child-specific rules. So that kind of goes back to the right to, generally consumers have a right to opt out of the selling or sharing of their personal information under the existing CCPA and CPRA. If the child is under the age of 16, they must provide opt-in consent before a business can sell or share their data. For children 12 and under, the parent or guardian must provide the opt-in consent for the selling or sharing of data. So kind of with the expanded definition of sharing, the scope of, you know, potential obligations relevant to children increases for kind of any website or online service, because, you know, to the extent that companies are using, you know, working with different advertising companies that are collecting data from website users for cross-contextual behavioral advertising purposes, there's now going to be an even more significant requirement to make sure that any users for whom the business's actual knowledge are 15 and under, that there's opt-in consent before that user's data is collected and shared for the advertising purpose. So I think the actual knowledge requirement is one bit of relief. You know, a lot of companies may not be collecting dates of birth, but this will be significant and mirrors the actual knowledge requirement under COPPA, which is the Federal Children's Privacy Protection Act, and already is only triggered if a business has actual knowledge that they are processing data of a child under the age of 13. One thing to think about, especially with this, is with the enforcement of COPPA, which is something that the California Attorney General can already enforce, businesses that are either geared towards teenage or child audiences may be facing additional kind of potential enforcement actions from many different sides. So including, you know, the federal enforcement of COPPA, the state level of enforcement by the Attorney General of COPPA, and now with the new enforcement agency, the CPPA, there may be potential enforcement actions related to children's data under the CPRA. So I think the moral of the story is that, you know, any companies that are, you know, processing data that they know belongs to children under 16, the risk is heightened with the passage of the CPRA. And I think, as we've seen with other types of enforcement actions, especially between California and Federal Trade Commission and other federal agencies, is that when one agency starts investigating, sometimes that can domino into the state agencies investigating. So it's going to be really important for companies to pay attention to the obligations that are specific to children to help manage some of this risk. And finally, this one is there's not too much new here in the CPRA, but we did want to flag, this is an important part of the law. There's an extended exemption for B2B and HR data. So currently under the CCPA, businesses are not required to comply with the full set of obligations for any data collected in the HR context, like employees, job applicants, beneficiaries of employees, and other circumstances, and also for B2B, certain B2B contact data. So the big kind of point under the CPRA is that those exemptions will be extended until January 1st, 2023. Under current law, they would have gone into effect on January 1st, 2022 through an amendment that the California governor recently signed. So that's good news for businesses who, either function, collect mostly B2B data and have had kind of limited obligations under the CCPA now. And also, I think generally any businesses with employees or independent contractors in California, this provides some additional time to figure out kind of the compliance obligations for all of that internal data.
Okay, and then lastly, I'm going to talk about the CCPA exemptions that were clarified and expanded. A lot of this is really helpful information. So because a lot of our companies we work with use these very kind of nuanced definitions. And I'm going to kind of walk through those. So first off, exemptions with regard to personal information. As you may already be aware, there's a few exemptions. One is the exemption for publicly available information. The first bullet here under this publicly available information definition was current. This is in effect right now with the CCPA, the lawfully obtained information from federal and state or local government records. These two additional bullets were added under the CPRA. And that is information that the business reasonably believes is made lawfully available to the general public by the consumer or from widely distributed media, or information made available by a person. Again, remember, person is business entity under the CPRA, to whom the consumer disclosed that information and for which the consumer has not restricted that information. So I would read that as a public social media exception. So both these are very useful, or could be very useful. So they're useful exemptions. They also track with what you see in a lot of privacy laws with regard to publicly available information. The CCPA definition of that was a publicly available information was very limited. You see a broader definition of that in other privacy laws like the Gramm-Leach-Bliley Act for publicly available data. And so these are useful exceptions to the definition of personal information. You also have a new exception for lawfully obtained truthful information that is a matter of public concern. That's all direct language. There is no guidance with regard to what that means. I imagine you could fit, COVID-19 reporting or something like that into this type of exception for a matter of public concern. No guidance. Maybe we'll get some through the regulations. They maintain the exception for aggregate consumer information, and that's a defined term under the CCPA, and that has not changed. But there's also a definition and an exemption for de-identified information, and that definition has changed. So I'm going to walk through that at this moment. So the personal information does not include de-identified information, which is now or will be under the CPRA, information that cannot reasonably be used to infer or link to a consumer, provided that the business, this is a new mechanism for qualifying information as de-identified or any subcategory. So it's worth noting what's required here. That if the company takes reasonable measures to ensure that the information cannot be re-identified, and it publicly commits to maintain the use of the information in its de-identified form and not re-identify it. So that if you're a business using this exception, that's a new privacy policy requirement. And third, that you contractually obligate downstream partners to comply with the business's commitments in A and B. So that's a new contract requirement if you are a business taking advantage of this exception. Notably, and let me make clear, this is not part of the CPRA, but there was an amendment that went into effect in early September for a new exemption for de-identified patient information that tracked to the HIPAA de-identification procedures. Those remove 18 data elements or get a third-party assessment of de-identification. It only applies to patient information, but interestingly, that new that new text also has a new, very broad definition for re-identification. The amendment states that it only applies to that subpart, but you have to imagine that a court looking at this would use that definition for re-identification. And also it's very interesting because, you know, most of us, maybe if you have printed out your CPRA text, it won't include this because you may not have picked up this amendment. Mine doesn't, so I had to look at this separate. Like I said, it's a broad definition for re-identification, and any enhancement of the identified data sets may trigger that re-identification standard. So worth noting there if you are taking use of this exception. There's also some new concepts that come into play with regard to the CPRA, and these are concepts that you see in other privacy laws. Very interesting to track these. Basically a concept of uses for security and integrity. And this use, I mean, security, I think we can all wrap our head around, but what is an integrity use? Here I've provided the definition, so this is a new defined term. And, you know, to resist illegal actions, seems like that could be a very broad use of this exception. This exception, and I've listed here, I won't go into all these specifics, but interestingly, this is one of the very few exceptions for responding to a specific pieces of personal information access request, which is maybe the hardest part to comply with from the CCPA. This is a new exception here. So it'll be interesting to see how this term is used. Also, the concept of impossibility or disproportionate effort concept you're maybe familiar with from the GDPR. It's used as an exception in a few places. Importantly, it's one of the very few exceptions for this new right of correction. And there's a requirement that the CPRA regulations will provide more guidance on how broadly this term can be used. So what are the next steps? So we've been talking here, a lot of this we've already stated, but kind of here's one chart to show it all. We know that before the CPRA becomes operative on January 1st, 2023, so you have about 2 years, there will be a lot of activity here with regard to the CPPA being created and funded, the board being appointed, beginning their rulemaking process in about 7-8 months. Also then finally implementing CPRA rules, or excuse me, regulations on July 1st, 2022. There's a look back period similar to what we had in the CCPA that will begin on January 1st, 2022. You see this starts looking like it's not as much time as we would hope. And then finally, the CPRA becomes operative on January 1st, 2023, about 2 years. And then about 7 months after that, or 6 months after that, the CPRA becomes enforceable. So we're at the question. I know we're almost out of time, and I know people have to go. Please feel free. But before we start questions here, and I think Erin and I can stay on for a few minutes if we have questions. You can submit them through the question and answer feature. If you do have to drop, please, I want to say thank you for attending today, but also just thank you for your interest in this, and thanks for trusting us with helping. You need help working through this complexity. We appreciate that. And with that, maybe I will have some time for questions here. Okay, we're gonna change with regard to the GLBA. No, I don't believe so. Erin, can you confirm that? I don't believe so, is the answer.
No, I don't believe there's any significant changes there.
Yeah, I'm confirming right now, but no. I think
another question.
Yeah, go ahead, Erin.
I was gonna say, another question we've gotten is when would be the best time to start updating for CPRA? There's still going to be regulations that are published by the enforcement agency over the next 2 years. I think it's important to realize where some of the new obligations will impact your business and potentially your business model. It's good to understand where those changes may be needed over the next 2 years, but for the most part, things like updating privacy policies and finalizing contractual updates, for a lot of those, I would probably hold off a bit until we get some more guidance to the regulations before, especially changing something like a privacy policy. Technically, none of those changes will need to go into effect until 2023.
Right, and I agree with that. I think where you're going to see a lot of changes early is with regard to your contracts. We saw that with the GDPR, companies, controllers asking for contract addendums before the GDPR was effective. We saw the exact same thing with regard to the CCPA, that basically businesses asking their service providers for contract addendums before the CCPA went into effect. I think it's very likely you're going to start seeing some of these contract requirements before the CPRA goes into effect. Okay, well, we're over time and I don't see any other questions. And I know that was a lot to throw at you in an hour. So if you do think of any other questions after this, do feel free to reach out to us. Again, we'll be sending out the presentation materials and a recording of this presentation after, and always feel free to reach out if you have any questions that come up. Hope you all have a great day, and we'll be talking soon.